Hello everyone and welcome to our final webinar of 2023. Thank you all for joining us today. My name is Kate Chalker, for those of you who don't know me, and also presenting with myself today will be Adrian Bailey. We're both based in Sydney and Adrian is the principal down here. As you would have seen in the advertising materials for today, we'll be conducting a bit of a review of the year that has been, and also providing some predictions or expectations for 2024. So before we jump into that, I'll just do a little bit of quick housekeeping for those of you who might be new to the system. So if you would like to download the slides from today's presentation, you can do so by clicking on the Files button, and that will allow you to download a PDF version of the slides. But if you have any issues accessing those, they will be included in the feedback email, which will be circulated later today. If you have any questions which come to mind throughout the course of the presentation, please feel free to submit those to us. You just need to click on the chat button, again on the right-hand side of the screen, and you can type those questions in there at any time during the presentation, and we'll keep an eye out for those questions. Also, just a reminder that today's webinar will be recorded and will be later uploaded to both our website and our YouTube channel. It's obviously very late in the year, and I'm sure many of you are rushing to complete your end of year jobs. So if you need to leave early or duck out during the webinar, don't be too concerned. You can always watch the webinar at a later time. So we'll just briefly go through the agenda before I hand over to Adrian. So looking at 2023, firstly, we'll go through a bit of a recap of 3 of the major tax cases which have been handed down this year, being Guardian, Bendel and Hayes. And then we'll also do a bit of a recap of the recent developments that have happened in relation to Division 7A and Section 100A and the Commissioner's recent publications regarding those provisions. From there, looking forward to next year, we'll be talking a bit about the potential rise in Next 5000 reviews from the ATO, also looking at what we think might happen with regards to asset protection and a rise in those types of queries, and then also giving a view as to what we think might happen in relation to sections 99B and 99C. So firstly, we'll go through the year that has been and start by addressing those 3 key cases, the first of which is Guardian, and Adrian will be taking us through that case. So I'll hand over to Adrian to give us that recap.
Thanks, Kate, and welcome to everybody to the last webinar of the year. Kate failed to mention that it is our 50th webinar that we've run since the beginning of COVID, so we've reached the half century, and obviously they're going to continue on in the new year. So Guardian case, important 2 aspects, or really 1 main aspect in terms of Section 100A and an examination of that. It is also Part 4A case as well. And as I run through it, we'll see that the taxpayer won on the 100A part, but failed on one of the years in relation to Part 4A, the general anti-avoidance provisions. In terms of Guardian and the overall structure and what had occurred was that there was a distributions in the 2012 and 2013 year via a trust to another company, and then a subsequent dividend in a later year from that company to the shareholder. Now, at the time of that dividend, that shareholder was a non-resident for tax purposes. And so the end result of that later dividend is, because it was a fully franked dividend, there was no further tax to be paid by the non-resident, and those funds were used to, in effect extinguish some Division 7A liabilities. So in terms of the overall case and the way that it developed through the courts and the most recent and final decision, it was the full federal court decision is that we had a lot of evidence from the taxpayer that all of the arrangement and the taxpayer's accountant, that all of this was done for a couple of reasons, one being asset protection and one being succession planning. So the taxpayer had been involved in business. He was involved in plantation businesses, tree plantation businesses, which he had sold, and he had some concerns about the funds that he'd received as part of that sale coming under attack by a disgruntled purchaser. The second aspect was that he had some children. He was looking to have them take over some of his affairs. They'd proven to be a bit of a disappointment, as children sometimes do. And so he had decided that even though he had looked to bring the children into the structures, he had to remove them from the structures, but he wanted to develop future structures that they couldn't mess up, if I could put it that way. So some new companies were established. As I said, there was some distributions from the old entities via a dividend from the old entities to a trust, which then distributed it to a new company, and then a dividend to him. And at that stage, he was a non-resident. So the tax office attacked it under those two limbs, Section 100A and Part 4A. By the time we got to the full federal court, they had lost on all accounts for 12 and 13 for both 100A and Part 4A in the federal court, in Justice Logan's decision. So the appeal only, in terms of Section 100A, only dealt with 2013. For Part 4A, it was still both years, 2012 and 2013. If you think it through in terms of the structure and the mechanism that was put in place, yes, there was a tax benefit at the end of the day. He received that dividend tax-free, or further tax-free, I should say, apart from the franking credits that had been applied, and he used it to extinguish some Division 7A liabilities. So in that respect, what was important from a 100A perspective was the question about whether there was a reimbursement agreement. And in terms of that aspect, what the Commissioner had to prove was that at the time that the trust made the distribution to the company that subsequently declared the dividend, there was an agreement, or there was an arrangement that the dividend would subsequently be declared, and he would receive it tax-free or without further tax, and use it to extinguish the Div 7A liability. On the evidence, that couldn't occur because there was no evidence that could show for either the 12 or the 13 year that he had at that time of making the distribution from the trust, or the trustee had, that he had in place this arrangement, which was eventually going to happen. And it was quite the opposite in relation to the 12 year, in that it wasn't decided until some time after that they would declare this dividend. And really, that's where a lot of 100A attacks from the tax office will fall down, because it's difficult to show, in the absence of something very blatant, it's difficult to show that at the time of making the beneficiary presently entitled, there was an arrangement that, in essence, someone would get a tax benefit. So that's where the Commissioner fell down on 100A in Guardian's case in the full federal court. Interestingly, in Justice Logan's decision, he went on to say, he reached the same conclusion, but he also went on to say that even if I didn't reach the same conclusion, I would say what had occurred, because of the evidence about the asset protection and the desire for succession planning and structure proofing for the kids, that this was ordinary family and commercial dealing. Now, the full federal court didn't examine that because they didn't need to, because they said there was no arrangement in 13. So with that, we still have the earlier decision of Justice Logan standing to say that in this sort of arrangement, that it's ordinary family or commercial dealing. So that's still the case in terms of relevant law, or case law, I should say. The other aspect of Guardian was the Part 4A assessments. And in that, they had a win and a loss in terms of the taxpayer. In the 12-year, the court found that you couldn't find a tax avoidance purpose because the later tax benefit, which had been identified in terms of him not paying further tax on the dividend, it wasn't envisaged in 2012 that would occur. However, since he had gotten that benefit before the 2013 year, the court found that, well, he's repeated the same thing. He knows that, this is my paraphrasing, he knows that there's going to be a tax benefit in the 13 years, so Part 4A can apply. So important to remember the mechanism and the requirements of Part 4A are completely different to Section 100A. As I said, Section 100A requires that reimbursement agreement in place. Part 4A doesn't. All it requires is a scheme of which there's a tax benefit. But an interesting outcome in that, as I said, 12-year, they couldn't show a tax avoidance purpose because they couldn't show that the later dividend would be declared, but it had been declared by the time of the 13-year, so they could show that tax avoidance purpose where we had, in essence, a repeat of the scheme in this circumstance. So that's Guardian. I'll talk about 100A again a little bit later, as well as mention B-Blood, which was another 100A case that we're not going to cover. But that's Guardian, which came through during the year and really reinforced the issue that the tax office will have in pursuing any 100A assessments against clients. Over to you, Kate.
Thanks, Adrian. All right, the next case that I will be discussing is the case of Bendel. And this was a decision of the Administrative Appeals Tribunal, which only came down 3 months ago on the 28th of September. And there were 4 issues before the tribunal, but the main one, or the one which has the most significance, was looking at whether a UPE to a corporate beneficiary constituted a loan for Division 7A purposes. So we'll briefly go through the facts of this case. So we had a discretionary trust which was controlled by the applicant, Mr. Bendel, and his brother. And there are a range of beneficiaries of the discretionary trust, one of which was a bucket company called Gleewan Investments Proprietary Limited. And so the trustee of the trust decided to make some income distributions to the bucket company between the 2013 and the 2017 income years. But as often happens, those distributions were not cash flowed to the bucket company. Rather, what happened was there was a current account recorded in the accounts of the trust and recorded as a liability owing to the bucket company. And if the trustee paid any expenses on behalf of Gleewan Investments, then the effect was that the current account was reduced by that amount. In total, the amount of the UPE was around $1.66 million, so a fairly substantial sum. And what happened was that the commissioner identified this UPE and decided to assess that amount, so the amount of the current account that was unpaid at the relevant lodgement day, decided to assess that amount as a deemed dividend under Division 7A, relying on the fact that it was a loan for the purposes of Section 109D. So if we look at the legislation itself and we go to Section 109D, specifically subsection 3B of the 1936 Tax Act, it specifies that a loan includes a provision of credit or any other form of financial accommodation. And so the Commissioner has had a long-held position since 2009, which was formalised in 2010 in Taxation Ruling 2010/3, to say that a UPE with a corporate beneficiary will be a loan under Section 109D3. So in other words, because the company is entitled to this money from the trust, but it does not call for that money, it's essentially providing financial accommodation to the trust, which would result in a loan from the company to the trust, triggering a deemed dividend under Division 7A. And so that's been the position since 2009 and most recently last year under Tax Determination 2022/11. The ATO really doubled down on that view to confirm that a UPE to a corporate beneficiary can be a Division 7A loan. However, the tribunal member found in favour of the taxpayer to say that the UPE was not a loan under the provisions of Section 109D. The tribunal member considered the UPE and found that it was not a loan either under the general meaning of that term or under the definition of Section 109D3. And so the tribunal member considered it more as a right created in equity than a loan per se. And the tribunal also highlighted the importance of looking at the statutory context of Section 109D, which includes subdivision EA, which is a more specific way of dealing with UPEs to corporate beneficiaries. And the tribunal found that if it were to accept the Commissioner's interpretation of the legislation, then it would have the effect of undermining the operation of subdivision EA, because it could have the effect of making the same UPE subject to tax twice. And the tribunal found that that was not the intention of Parliament when this legislation was implemented. If it was the policy intent to make these types of UPEs a loan for Division 7A purposes, then Section 109D would have been drafted in that way, but it was not. And the tribunal member also said that subdivision EA was not drafted in a limited way to say that it only applies when Section 109D does not apply. And so you would have that potential double taxation effect. And so the Commissioner found in favour of the taxpayer to say that a UPE cannot constitute a loan under Section 109D. So that was a big win for the taxpayer, but where does that leave us now? We know that the Commissioner has appealed the decision of the tribunal to the Federal Court. Not surprised by that because of the wide ramifications that this judgment could have. However, we know that the Commissioner has not withdrawn the existing tax determination and is going to continue applying that view until we do have the outcome of the appeal. We do have some objections currently lodged with the ATO on behalf of clients that are looking at UPEs, and we've been told by the ATO that they won't be looking at any of those objections considering those UPEs until we do have the outcome of the Federal Court appeal. And there are certain provisions in the legislation that allow a taxpayer to compel the Commissioner to rule on an objection. And so the ATO advised us that if we were to trigger that power, that the ATO would apply their existing position under last year's tax determination. So important to remember that the Commissioner is not bound by the decision of the tribunal, and so they will continue applying their existing view until we do have that Federal Court judgment. And because of the wide ramifications, if they were to lose on that appeal, I would not be surprised if the ATO appeals the decision all the way to the High Court if need be. So really, we don't have much change at the moment until we do have that Federal Court decision. So we're a little bit left in limbo until we do have that appeal finalised, but definitely an interesting case. Will be interesting to see how the Federal Court views the matter. But yes, definitely a watch this space in relation to Bendel, see if we have a decision from the Federal Court, perhaps in the second half of next year. All right, so that's the case of Bendel. I will hand over to Adrian again to take us through the case of Hayes.
Thanks, Kate. And certainly, I've seen some commentary about, in terms of Bendel, how our taxpayers should go and amend their assessments if they have been assessed in relation to UPEs. But clearly, the ATO is going to continue to push their view regardless of the AAT decision. So perhaps not a wise course of action. The last 23 case that we're going to talk about is Michael John Hayes Trading as trustee. That should be MJH Trading Trust. Sorry, there's a typo in the slide. And the Commissioner of Taxation. So this is another Part 4A case, and it's one involving the use of dividend access shares within the client group. We were involved in the initial implementation of the structure and also in the tribunal representing the taxpayers. The matter is under appeal to the federal court, so I've got to be a little bit circumspect about what I say. But in terms of the initial decision in the AAT, the reality is that what we had in this situation was it was a group of 4 brothers who had developed a series of diverse businesses. And the overall intention amongst them was that they were going to share equally amongst the 4, regardless of their involvement, in the profits and the growth of the assets within the different businesses. Because they had a number of different diverse businesses in a regional town, as they've grown and as they've developed, quite often the entities that were established, and predominantly companies, weren't established in line with what their objectives were, where if there was only 2 brothers around or 3 brothers around and they're looking to set up a company to buy a new business or to buy a new block of land or something like that, then there would only be 2 shareholders or 3 shareholders as opposed to the 4 that was the intention. So they built this up over 20 odd years. They get to the position where they're trying to look to make sure that if one of them were to pass away, that their share or their quota would be available, irrespective of the fact that they may not have ownership in a particular asset or company. So one of the things that was suggested, one of the things that was done, there was a variety of things done for these clients, was to issue dividend shares out of these companies to 4 separate entities representing each of the brothers, and to declare dividends of retained profits out. That way, we're achieving 2 objectives. One being asset protection, because a lot of these trading entities were in high-risk businesses, for example, trucking, and also storage of petrol. Which they had already had litigation against various aspects of some of their businesses, so they're well aware of the risks. The other aspect would then allow effectively a square up or a true up amongst the 4 brothers, where different dividends could be declared to their entities, and so they end up effectively each having a quarter of the retained profits or the value of the separate entities. So that was the overall strategy and overall discussion in relation to Hayes, or the Hayes brothers. And then the tax office came along, and effectively there was an earlier court matter which the clients also won in relation to some of the structures. But the tax office came along later on under alternative assessments under Part 4A and said, what we think you have done in relation to the declaration of the dividend itself is dividend stripping under Part 4A, and they assess them under the alternative assessments for Part 4A. So dividend stripping traditionally is where you have a capital benefit to one shareholder that is tax-free and a dividend to another in reality. So what the tax office took the view in this one is that because the dividend went to, in effect, companies, there was no further tax to be paid. The taxpayers, being the individuals, received a capital benefit in that they didn't pay further tax on the dividend if they'd taken it out to themselves as ordinary shareholders. And then there was the dividend, obviously, to the other entity. In what I would consider, and it's not because I was involved, but a very well-worded judgment, in terms of the tribunal member found that there was simply no tax avoidance purpose. When you look at what had occurred and the reasons for doing it, they weren't doing it to avoid tax at all. And so there couldn't be Part 4A applied and there couldn't be dividend stripping. I had hoped that the matter would then be the end of the matter, but unfortunately the tax office have decided to appeal, and it will be decided now in the federal court in next year sometime. So with Hayes, it gives you some comfort in relation to the use of dividend access shares in that clearly where there's no tax avoidance purpose, such as in this case where it's purely for asset protection, and then also the true up and the tidy up amongst the brothers, then Part 4A should not apply. And that's certainly the view of the tribunal, which I think is the correct view. Unbiased, of course. Moving on to other aspects of 2023, as Kate went into Bendel and the implications of that, Remembering that 2023-2024 is the first year of the Commissioner's new view on UPEs, corporate beneficiaries. So recapping on that, effectively the concept of sub-trusts are out, or any other sorts of arrangements that you used to be able to do under the old tax ruling. And now, in essence, you either cash flow it to the company or you enter into Division 7A loan. So that's what the Commissioner has said that you can do to comply with Division 7A when we have an unpaid present entitlement to a corporate beneficiary. Of course, Bendel comes along and puts us in the position now, well, okay, well, this is what the Commissioner says you can do. However, the court says that it is not subject to Division 7A, or sorry, I should say the tribunal says it is not subject to Division 7A. So that really puts taxpayers in the position where they have a reasonably arguable position, but if they choose not to follow the Commissioner's view, they're relying on the view of the tribunal. That is reasonably arguable. So puts everyone, I guess, back into a state of flux. The Commissioner had really changed, in my view, gone to his new view on the basis that the long-promised legislation hasn't come through. Certainly no prospect of that, or no indication of that anytime soon. So continued uncertainty in Division 7A, I think, would be the right way to address it. Kate's going to set up a poll now, or start a poll on Division 7A. All of these are anonymous. We don't know what you choose in terms of your answer, so don't worry about that. And we'll get a result at the end of the poll, which will say what percentages of people answering this out of that. So just curiosity more than anything. Poll for Division 7A. What are you going to do with UPEs, corporate beneficiaries, in the 23-24 year? Are you going to make them a Division 7A loan as per the ATO? Are you going to cash flow them? Are you going to leave them as UPEs, thanks to Bendel? Have you moved away from creating them in the first place? Or are you going to do something else? Feel free to tell us, not during the seminar, webinar, because this is recorded. But if there is something interesting that you've come up with, let us know. We're always interested to talk to people about what they're up to. So we'll just let that run for another second or so to give everyone the opportunity to go through that poll before we close it off. But it looks like from numbers are going up and down a little bit, but it would look like, about the most common answer is going to be, we'll make them a Division 7A loan, and I can understand that. No one really wants to have a fight with the tax office, or you won't create them in the first place. So you'd be either you've moved from a trust to a company environment, and you don't create them. And I think Kate's closed off the poll. So yeah, most popular choice was if they're going to be there, you'll make them a Division 7A loan, followed by won't create them, cash flowing, leave them as UPEs, thanks to Bendel. There's roughly 1 in 10 responses say that. And then no one said something else. So they must be keeping their secrets to themselves. Moving on to 100A, in terms of the changes during the year. And really they came about because we had the finalisation of the initial guidance or tax ruling 2022 in December 22, which significantly watered down from the first draft based on feedback and responses in relation to the first draft of the Commissioner's view on 100A. It's been further updated. It's September 23 as a result of Guardian and B-Blood. So we didn't go through B-Blood. B-Blood was a scheme in reality, a very clever scheme. But one that was found to be subject to 100A and Part 4A because it was effectively mass marketed. So it's hard to say that there wasn't an agreement or arrangement under 100A because that was all part of the plan. So there have been some updates to the tax ruling, effectively playing down Guardian and talking up B-Blood because the Commissioner won in B-Blood, of course. Regardless of that, so I think a lot of people are a lot more comfortable with 100A these days. And we do have another poll, hopefully, on 100A, which Kate will start soon. In terms of that aspect and 100A, I think people are a lot more comfortable that what seemed to be a fairly, strange guidance from the Commissioner and seeing 100A at every corner, in every distribution, I would say people are a lot more comfortable that 100A doesn't apply in most circumstances. That being said, we are seeing more requests and more versions of what you'd call a family objectives document, or something along those lines, where it outlines the reason why you're distributing to children, for example, and leaving it unpaid. So people just building up that evidence file. We're seeing a lot more of that out there in practice. If we can get our next poll running, Kate, I'm not sure whether we can or not. Oh, there we go. So 100A poll. Do you still distribute to family members and leave unpaid? Yes, no, never did. So we'll let that run for a couple of seconds or 30 seconds or so just to see the responses. But as I said, 100, or as we've discussed in other webinars on 100A, it's been a fairly big stick that the tax office have threatened. But the reality is it's very difficult to show that there is a reimbursement agreement. And so we'll close off the poll now. It looks like pretty high majority saying they still distribute to family members and leave unpaid. And personally, I think there's many valid reasons to do that. Not the least of which is in reality, thanks to the decision of Logan and Guardian, I would say that's ordinary family and commercial dealing to do that, particularly where you can show reasons why you've done it in terms of building wealth and so forth, and other sorts of reasons that we've discussed on other webinars. Moving on to 24. So just to recap what we're going to be talking about, we're just going to touch on the Next 5000 project because we're seeing quite a few of those come across our desk. Asset protection issues, and again, we're seeing an increase in asset protection queries, I think for a variety of reasons, and then touch on 99B and 99C. So kicking off with the Next 5000, if you haven't had the experience of a review yet, you have clients that fit in with the threshold, then it's probably just a matter of time before one pops up. So this was, originally we had the top 500, so that was the top 500 taxpayer private groups by wealth, and then that's expanded to what's called the Next 5000. So their initial threshold is where a client group had a net wealth of more than 50 million. There's actually 7,000 private groups that fit into that threshold. So the Next 5,000 is really the next 7,000. Probably going to keep growing. We have found that there are clients that are getting reviewed for other reasons, then get drawn into the Next 5,000 net, who are not within that $50 million threshold. And where we've seen that a few times is where clients have done where they've interposed a holding company between a trading company, for example, and individual shareholders, and declared a dividend down to the holding company to get it away from the trading entity. There is a taxpayer alert where some people have been using those sorts of arrangements and then doing some other things in relation to repayment of Division 7A loans on the basis that the holding company has no distributable surplus at that time, so there's no deemed dividend. So there is, and I have seen some people getting around town a few years ago now suggesting that clients should do that. But I have also, a function of that is clearly the ATO are looking for that sort of scheme. And one of the ways that they look for it is to combine both the data from doing a rollover or interposing a holding company and declaring a dividend. So I have seen a couple of clients picked up for that, and then they've moved on to a Next 5,000 review. It is what they call a streamlined assurance review. Like with many things in life and in the public service, there are long checklists that they will send to you of things that they want to have a look at. For the most part, we've found them to be fairly, what do you consider to be educational or not overly aggressive in the way that they are doing it. But of course, whenever you have a look at client matters and client files, there's sometimes things that you look at and think could have been done better. So if you do get those, we're more than happy to help out in the background, and that's the way that we've been assisting clients so far for the most part. where we assist with the provision of vetting the provision of information to the tax office, or discussing strategies in terms of voluntary disclosure and those sorts of things. But the correspondence is still coming from the referring accountant, because we find that then makes it work through the system a bit easier than having lawyers involved as the ones writing letters. So they are out there. As I said, if you haven't experienced them yet, no doubt if any of your clients fit within that threshold, you're very likely to over the next year or two. I'm going to throw over to Kate, who's going to talk about some asset protection issues.
Thanks, Adrian. Yeah, as Adrian mentioned earlier, we have seen a real increase in asset protection queries in the past year. And I think we can put this down to a few different reasons. Obviously, it's been a difficult year economically and financially for a lot of people. We've got the cost of living pressures, we've got inflation, we've got the monthly interest rate rises. We've also seen the collapse of many different building and construction companies. And I think we're still also seeing some of the flow-on effects of COVID-19 and the end of those insolvency protections, because it obviously takes a long time to run claims and bankruptcy, liquidation through the court process. So I think we're still seeing some of those matters come to light. And then, of course, you also have some more unexpected claims or left field claims that are sometimes published in the media that can cause concern, particularly for business owners. For example, there was a case earlier this year where there was an employee who was working from home who was attacked by a dog. And the decision in that case was that that injury was found to be done in the course of her employment. And so the employer was found to be liable for the workers' compensation for the injury suffered by the employee. So those types of matters which can be published online and discussed amongst people can really strike a lot of fear into people and make them question, what if that happens to me? Are my assets protected? And so there are a range of different things that we can do to assist clients with these types of queries and to protect assets held personally, assets held within companies, and also assets held within trusts. So I'm not going to go through these strategies in detail. I'm sure you've come across these types of strategies before, but what we often do for individuals who are in business or who are just concerned about their assets in general, we would implement our secure debt strategy, whereby the individual would make a gift to a discretionary trust or a bloodline trust which they control, and the amount of that gift would be equal to the net value of their personally held assets. And then you would have the trust loan that amount back to them and take security over their assets in the form of a registered mortgage over their real property or a security deed over their personal property. And so the effect of implementing this structure is that the assets remain held by the individual, but we have that corresponding debt to the trust which they control. So if it's implemented properly and it's outside the clawback period, then the effect is that if the individual were sued, whilst they still own those assets, there would be nothing left there at the end of the day for the creditor to access. Similar structure for assets held within a company. We would have the gift by the trading company to the holding company, and then the loan back from the holding company to the trading company, and preferably the shares in the holding company would be held by a discretionary trust, again controlled by the same individual involved in the trading company. The reason why we have the gift going to the holding company and the loan back from that entity is for Division 7A purposes, to avoid that potential deemed dividend. So whether we're dealing with personally held assets or assets within companies, there are structures we can put in place to protect these types of assets. With all asset protection work, it's ideal to implement the work earlier rather than later because of the clawback provisions that can apply to unwind these types of transactions. But certainly we expect to see a lot more of this work in the next 12 months with the concerns continuing. And so, yes, that's one of the main things which we expect to see in 2024. So I'll hand over now to Adrian to touch on our last prediction for 2024, being section 99B and 99C.
Thanks, Kate. 99B and 99C, and this, I guess, as to whether it occurs or not, but they are provisions that have been around for a long time, but there tends to be a bit more activity from the tax office in relation to them. And the way that they operate is, so 99B provides that any amount being property of a trust estate where it's paid to or applied for the benefit of a beneficiary of the trust estate who was a resident at the time is assessable income. There are some carve-outs in 99B2 that say that, well, it doesn't apply if it's corpus, unless it's untaxed corpus, and by that I mean it hasn't been brought to tax in Australia if it was taxable, or it's nanny, something along those lines. So where we see 99B and 99C being raised is really where we've got non-resident beneficiaries, or we've got a non-resident trust, all those sorts of things coming into play. And the world being what it is, we're seeing a lot more of those these days. The issue is 99C provides a very wide wording for whether something was paid to or applied for their benefit. So it may not even have been paid or applied for, them may be left in the trust, and technically 99C would still apply. The issue with this is, because there's been a bit more activity in this area from the tax office, is that professional bodies and so forth have applied the ATO for guidance. I don't think that's a great idea. We've seen what's happened when people, when professional bodies seek guidance from the ATO. The guidance that comes back is never great. And certainly we saw that with the 100A guidance last year. So just raising it as an issue, if you do have clients with multi-jurisdictional assets or trusts, just bear in mind 99B and 99C are there, they've always been there, but could have some issues. So just to use an example, seeing that we've had to consider it recently for a New Zealand-based trust that was distributing some funds to an Australian resident. So the question is whether that's taxable to the Australian resident or not. So that brings us to the end of what we're going to talk about in our webinar. As Kate mentioned, you will get I'm just going on mute. Feedback. You will get a feedback questionnaire at the end of or partway through today, I should say. If you could take the time to complete it, it's not a long questionnaire. Often our topics are taken from requested topics within that feedback questionnaire. The video will be recorded and will be uploaded at a later stage to our YouTube channel and website. Not only is it our 50th webinar, but next year, 2024, marks the 30th, as in 30 years, the 30th anniversary of Cleary Hall beginning to provide workshops to accountants and other advisors via the Legal Resource Club. So that's 30 years of, obviously these days they're mainly online, but 30 years of presentations, face-to-face, in-person days. So again, a reasonable achievement, I would say, getting to 3 decades. But yeah, we look forward to obviously continuing to present them and continuing to see everyone in the new year. I'm going to turn off my audio so Kate can say her farewells.
Thanks, Adrian. Yeah, thanks to everyone for your continued attendance and participation throughout the year, coming along to our webinars. And it's been great working with all of you throughout the year, and we look forward to seeing you all in the new year. Hope you have a wonderful Christmas, have a restful break, and come back in January feeling refreshed and ready to go.